Unit 11. Intellectual Property. Unit 11, page 149. Listening 1.
Well, good morning, ladies and gentlemen. I'm going to be talking to you today about a hot topic in the area of intellectual property law. It's the topic of business method patents. It's an area where a lot of change is occurring right now, and so it's quite exciting. One of the senior partners of the firm, Mr. Whittaker, has told me that the firm's just landed an important new client with a case involving a business method patent for an internet sales application. I'm told it deals with a one-click ordering solution. I understand that you'll be shadowing the senior lawyer assigned to this case, and so I'll be covering the topic with you in detail. I'll begin with the basics, and then we'll move on to look at a few landmark cases. Each of you will be assigned one case to research and then to present to the group. Don't worry, you'll have plenty of time to do the research between sessions, and then you'll summarise the case for the others. Finally, I'll discuss the present situation and some recent holdings. Feel free to interrupt me at any time if you have any questions. Right. Well, allow me to start by going over what happens when a person tries to get proprietary rights for their invention. Naturally, an application is submitted to the Patent Office. The examiners at the Patent Office decide whether an invention deserves to be awarded a patent on the basis of certain standards. These standards, also known as requirements, are set forth in the patent statutes, as you know. But what are these standards? What determines the patentability of an invention? Let's have a look at the requirements. The first requirement is that the invention must be useful. This is also known as the utility requirement. This requirement is met if the invention is operable and if the invention provides what's known as a tangible benefit. Tangible in this case means substantial or real, so that we can say that utility refers to a real benefit that the invention provides. The second requirement is that the invention must be novel. Naturally, novel means new, in the sense that the invention mustn't be anticipated by another patent which has already been granted, or by knowledge which is already in the public domain. The third requirement is called non-obviousness. This word refers to the quality of something being not obvious to a person who has ordinary skill in the art. Okay, so much for the first three requirements of utility, novelty, and non-obviousness. There's a fourth requirement as well, and this is the one that's particularly relevant for the issue of business methods. This requirement governs the issue of what constitutes patentable subject matter. Things which are generally considered patentable are processes, machines, a composition of matter, such as a synthesized chemical compound, and so on. These are rather broad categories, of course, but here's where it gets interesting. There have traditionally been exceptions to patentability in certain specific cases. This means that certain subject matters, such as business methods, have been barred from patentability. Yep, that's right. Traditionally, business methods could not be patented. We can assume that the thinking behind this was that abstract ideas can't be patented. Recently, however, some important decisions have put an end to this practice. I'd like us to have a look at some landmark cases.